Hello, my dear future charters. I'm sure that you must have prepared yourself very well for the purpose of examination, and you must be waiting for the exams now. You must have already appeared for various prelims, which are conducted by different coaching classes, and probably you must have already appeared for the MTP, that is model test papers, which are conducted by CA Institute also. Now, in this lecture, I'm going to talk about the MTP 1 on the subject of law. So I'm quickly going to give you the guidance. How are you going to approach the question paper and how are you going to solve the same? So without wasting time, let us go ahead quickly. Let me share my screen. Okay, so here is the sharing of my screen. All my chartered accountants are waiting for discussion. Let us go ahead. Yeah. So this is the question paper. What does it tell us now? Okay. The section A is of business clause and question number 1 is compulsory, and any 4 questions are to be solved from remaining 5 questions. So they have told us clearly that question number 1 is compulsory and any 4 out of 5. So while discussing, I'm going to discuss entire question paper, but you are going to write not all the answers. Obviously, first question compulsory and any 4 out of 5. Let us consider the first one. Ashwin goes to supermarket to buy air conditioner. He selects a branded air conditioner having a price tag of rupees 40,000. After a discount of rupees 3,000, Ashwin reaches at cash counter for making the payment, but cashier says, "Sorry, sir, the discount was up to yesterday. There is no discount for today. Hence, you have to pay rupees 43,000. Ashwin got angry and insists for rupees 40,000. State with reasons. Okay, state with reasons. Whether under the Indian Contract Act of 1872, Ashwin can enforce the cashier to sell at discounted price of rupees 40,000. So this is the situation. In that case, remember, whenever there is a case law situation, you are able to divide your answer into 3 parts. Number 1, the provision of law. Number 2, the observations. And number 3, the conclusion. How are you going for it? As far as possible, please prepare 3 different paragraphs. Each paragraph having a heading. This is the provision, this is the facts of the case, and this is the conclusion. That's what you are able to go for. So here you can see that the question is talking about offer and invitation to offer. This is basically a question of offer and invitation to offer. The price tags which are mentioned or which are kept along with the goods or pasted on the goods are actually speaking not an offer, but they're an invitation to offer. So the price tag of 40,000 with after deducting the amount of discount, obviously just an invitation to offer. It does not amount to offer. So Mr. Ashwin, when he's carrying that particular commodity or those goods onto the cash counter and asking the cashier for the purpose of getting the discount, he cannot specify that the cashier or the shop has already made an offer and Ashwin has accepted the same. In reality, Ashwin has made the offer and it is up to the shopkeeper, up to the cashier to decide whether to accept Ashwin's offer or not. Unless and until there is offer and acceptance, there is no binding contract which is coming into existence. Invitation to offer does not amount to offer. That means the price tag is not an offer. Ashwin picking up the goods is not an acceptance. Therefore, there is no valid contract. That means Ashwin cannot enforce the cashier to sell the goods at a discounted price of rupees 40,000. Okay. Next one. Next one is Mr. Mohan had purchased some goods from Sunflower Limited on credit. A credit period of 1 month was allowed to Mr. Mohan. Before the due date, Mr. Mohan went to the company and wanted to repay the amount due from him. He found only Mr. Ramesh there, who was the factory supervisor of the company. Mr. Ramesh told Mr. Mohan that the accountant and the cashier are on leave. He is in charge of receiving money and he may pay the amount to him. Mr. Ramesh issued a money receipt under his signature. Okay, money receipt is also issued. This is very important. Issued a money receipt under his signature. After 2 months, Sunflower Limited issues a notice to Mr. Mohan for non-payment of the dues with the stipulated period of time. Mr. Mohan informed that the company that he had already cleared the dues and he is no more responsible for the same. He also contended that Mr. Ramesh, who is an employee of the company, to whom he had made the payment, and being an outsider, he trusted the words of Mr. Ramesh as duty distribution is a job of the internal management of the company. Analyze this situation and decide whether Mr. Mohan is free from liability. There are 2 different concepts under the company law. Remember, they have mentioned the word Sunflower Limited. That means this is not a question which is covered in relation to a normal contract act. This is not a question which is covered under the Indian Partnership Act, but this is covered under the Companies Act. The moment you are thinking about Companies Act, there are 2 very important concepts, 2 very important doctrine. One is the doctrine of indoor management and one is the doctrine of constructive notice. Under the constructive notice, we are trying to protect the company. from the outsiders. And under the indoor management principle, we are trying to protect the outsiders from that of the company. Now here you can see that Mr. Mohan had gone for payment before the due date. Mr. Mohan thereafter was told by a company employee that the accountant who is in charge of collection of money is absent, is on leave, on a vacation. And most important, thereafter he has also issued the receipt upon collection of money. Since Mr. Ramesh has offered a receipt under his own signature to Mr. Mohan, it is obvious that Mr. Mohan can be rest assured that probably the company has made an arrangement upon the vacation time of the accountant that the factory manager can collect the money. In this case, it is obvious that the outsiders will not be protected from the internal management of the company. Outsiders are totally safe to assume that the company must have made different arrangement. So in this case, Mr. Mohan is not at all liable. The doctrine of indoor management will come into picture. Don't forget to write in the facts of the case about indoor management. Okay. Then comes the next one. Classify the following transactions according to the type of goods they are. Okay, 4 marks question. 3 different things are there. A wholesaler of cotton of 100 bales in his godown. Okay, 100 bales in his godown. Since he's using the word in his godown, that means these are existing goods. He agrees to sell 50 bales and these bales are selected and set aside. Very good. Matlab, now 3 things are already done. Number 1, the goods are already in existence. Number 2, the goods are selected and they are set aside. That means the contract is of existing goods and this involves ascertained goods. So what are these goods? These are existing as well as ascertained goods, because the goods are already in godown, that means they are existing. The goods are set aside, that means they are ascertained. Okay. Next one, Mr. A agrees to sell B 1 packet of sugar out of a total lot of 100 packets lying in his godown, lying in his shop. Okay, very good. Since they are already lying, that means they are again existing goods, but 1 packet out of 100. Now, which one is not selected? Which one is not set aside? That means these are existing goods, but they are unascertained goods. So I'll say it is existing, but unascertained. Next one, T agrees to sell S all the apples which will be produced in his garden in the year of 2023. So here the goods will be produced. That means these are not existing goods. These are future goods. So they'll have to be considered as future goods. There is no need to consider ascertained or as the case may be. So these are future goods. What you're required to do, you are just required to specify that since the goods are lying in the godown, they are existing goods. Since they are already set aside and selected, that means they are ascertained goods. Therefore, the cotton bales transaction is of existing and ascertained goods. In case of question B, you should specify since the goods are lying in the shop, they are existing goods, but they are not yet ascertained. 1 of the packets of sugar out of the 100 packets are in question. Therefore, they are unascertained goods. So it is existing and unascertained goods. And in the third case, you can specify since the goods or apple are yet to be produced, they are future goods. That's what you are required to write. Please don't write only the answer, existing, ascertained, or existing, unascertained, or future. Please write the reason behind the same, because the question is for 4 marks. Okay. Then comes the next point. Question number 1 is over now. A compulsory question is completed. Let us go for the second question. An anticipatory breach of a contract is a breach of contract occurring before time fixed for the performance has arrived. Also discuss the effect of anticipatory breach of the contract under the Indian Contract Act of 1872. Very good. This is a question of 7 marks. So what is the meaning of anticipatory breach? Anticipatory breach means when one of the parties to the contract is of the opinion that he or she cannot perform the contract, then instead of waiting for the due date of the contract, the party approaches the other party. The party in default approaches the other party and communicates his unwillingness to complete the contract or inability to complete the contract well in advance. This is called as anticipatory breach. Anticipatory breach is communicated well in advance prior to the actual due date of performing of the contract. Now, what are the benefits of anticipatory breach? In case of anticipatory breach, the party to whom anticipatory breach is communicated has got 2 different options, either to cancel the contract immediately or to continue with the contract, and then to allow the contract either to get completed or to get dishonored or to get broken on the due date. But if the contract is kept alive like this, if it is not immediately cancelled, in that case, if any supervening impossibility occurs from the date of communication of anticipatory breach to the date of actual due date of performance of the contract to the date of performance of the contract, then the other party who has already communicated unwillingness or inability to complete the contract can take the benefit of supervening impossibility and can get out of the contract without paying any damages. So these are the points which are required to be covered in the answer. Let us quickly check what the institute has given the answer for. Yes, let us consider the question number 2. What is the long answer which they have given? Okay. Anticipated breach is a contract. Breach of a contract is a breach of contract occurring before the time fixed for the performance has arrived. Okay, it is in advance. When the promisor refuses altogether to perform his promise and signifies his unwillingness even before the time for performance has arrived, then it is called as anticipatory breach. Here they have not given any example. You can see in the model answer also, because the question is not asking you to explain anticipatory breach by giving suitable examples. So if you write examples, that's not a problem. But it does not mean that you should have written the example or should have written the examples compulsory. Next is effect of anticipatory breach, either to treat the contract immediately rescinded and sue the other party for damages for the breach of contract immediately without waiting until the due date of the contract has or due date for performance has arrived. And last one, may elect not to resign but to continue. Then the other party gets the benefit of supervening impossibility. These are the points which I have already discussed. Let us consider next one. LLP is an alternative corporate business form that gives the benefit of limited liability of a company and the flexibility of partnership. So now they have considered here that you are required to explain. सिर्फ explain करने को बोला है. क्या बोला है? Alternative corporate business form which gives benefit of limited liability and flexibility of partnership. Now, what is the meaning of limited liability? Limited liability means the liability of the owner or liability of the contributor is limited to the extent of contribution he has made for the business. This is the basic principle coming from joint stock companies. So it becomes easy for a person to work in such a situation without worrying about his private property getting attached for the responsibilities or for the liabilities of the particular business. That benefit was available earlier only to joint stock companies. Now it is available for limited liability partnership. And second point, flexibility of partnership. In case of a joint stock company, the creation of joint stock company is a lengthy process. It involves a lot of different permissions to be obtained from company registrar. It is not something which can be done by the shareholders or the promoters on their own by just making an agreement. On the other hand, partnership is by way of an agreement, mutual agreement. In that case, it is possible for people to come together without taking a lot of different permissions from the registering authority. They can form on their own according to the rules and regulations which they want to create on their own. That's the flexibility of partnership. So yes, in LLP, both the different things are covered. So this question is for 5 marks. You are required to write basically what is the meaning of limited liability, what is the meaning of flexibility of partnership, and then you have to required to mention that in LLP, both these different facilities are available. Hence, the statement is correct. Next one, question number 3, whether a minor may be admitted to the business of partnership firm. Explain the rights of a minor in a partnership firm. I am very sure that you may find this question to be very important and easy question. Minor, basically, you are going to specify that under the Indian Contract Act, a minor is not competent to contract. He is not having capacity to enter into contract, and partnership comes out of agreement. Therefore, by default, a minor is not capable of entering into a partnership. However, an existing partnership can admit a minor as a partner. In this case, the minor can be admitted only for the benefits of partnership. A minor cannot be held responsible for the liabilities of the partnership. These points must come in the introductory para of your answer. And then you should specify the rights of the minor partner. So first para is, under the Indian Contract Act, a minor cannot be party to the contract because he is incapable of entering into a valid contract. However, under the Indian Partnership Act, it is possible for an existing partnership firm to admit a minor as a partner in the partnership firm. First para is complete. Second para. In this case, when a minor is admitted by an existing partnership firm to the benefit to the partnership, he can be admitted only for the benefits of partnership. He cannot be held responsible for the liabilities of partnership. These 2 paras are complete. Then you can specify what are the rights of the minor partner. Number 1, he is having a right to share the profits. Number 2, he can ask for books of accounts, inspection of books of accounts to ascertain his own share of profit. Number 3, when he is interested in getting out of the partnership firm, then he can sue the partnership firm for share of profit. But till the time he decides to continue with the partnership firm, then he cannot sue the other partners for the same. He can ask for inspection of books of accounts, but cannot sue for his share of profit till the time he continues as a minor partner. But he decides to sever his ties from the partnership firm, then he has got a right to sue the partnership firm for the share of profit, which probably other partners are not giving it to him. And then last point, you have to mention about upon his date of becoming major, what are the responsibilities which is required to have, and what are the rights which is having. He can either elect to continue as a partner, or he can choose not to continue to be a partner. If he decides to continue to be a partner, in that case, whatever his earlier profit is there, that will continue, but he will also have to share the losses. If he decides not to continue as a partner, then he is required to give a public notice, and from the date of public notice, he will not be liable for the liabilities of the partnership firm. These are the points which are required to be mentioned when it comes to partnership. Don't forget, if you can write, don't forget to write section 30 of the Indian Partnership Act. Okay, so these are the points which you can consider here. Next is Mr. Gaurav and Mr. Vikas entered into a contract on 1st of July 22, according to which Mr. Gaurav had to supply 100 tons of sugar to Mr. Vikas at a certain price, strictly within a period of 10 days to the contract or of the contract. Mr. Vikas also paid an amount of ₹70,000 towards advance as per the terms of the above contract. The mode of transportation available between their places is roadway only. Okay, only roadway. Very good. Is roadway only between their places. Is roadway only. Severe flood came on 2nd of July 22, and the only road connecting their places was damaged. Okay, so that means this becomes a contingent situation which was not anticipated. So this becomes a supervening impossibility. Could not be repaired within 15 days. Okay, great. Mr. Gaurav offered to supply sugar on 20th July 22, for which Mr. Vikas did not agree. On 1st of August 22, Mr. Gaurav claimed compensation of ₹20,000 from Mr. Vikas. Okay, for refusing to accept the supply of sugar, which was not there within the purview of the contract. So in the contract, it was not mentioned that if the buyer declines to take the delivery, then what is the damage to be demanded. Next, on the other hand, Mr. Vikas claimed for refund of ₹70,000, which he had paid as an advance in terms of the contract. Analyze the above situation in terms of the provisions of Indian Contract Act of 1872 and decide on Mr. Vikas's contention. Who is Vikas? Vikas is the buyer. And what is his contention? His contention is to claim the refund of ₹70,000 of advance. So you are required to specify, first of all, whether Gaurav or Vikas, who is correct, and then you are required to specify what are the next steps for Mr. Vikas to do. First thing, under Indian Contract Act, we have accepted that there can be a supervening impossibility, which can take place when the contract was entered into. At that time, the impossibility was not there, but thereafter, the contract has become impossible on account of something which was not possible to be anticipated. Then such contract automatically becomes to be void. At the time of entering into the contract, it was a valid contract, but because of a supervening impossibility, it becomes now a void contract. So in case of supervening impossibility, the party who has got any benefit under the contract is required to refund the same, return the same to the other party, and cannot enforce the other party to perform the contract after the supervening impossibility is over. The other party may or may not, but there cannot be a compulsion that the contract must be performed. So Mr. Gaurav is not having a right to force the contract for delivery of sugar to Mr. Vikas. He does not have a right to demand damages. And Mr. Vikas, on the other hand, has got every right to claim refund of the advance paid by him to Mr. Gaurav. Okay, so these are the points to be mentioned when it comes to the question number, second sub question of question 3. Let us go for question number 4. Let me just have a sip of water. Yes. Now question number 4. It tells you explain any 6 circumstances. Any 6. That means you are not required to write all. Any 6 circumstances in detail in which a non-owner can convey better title to the bona fide purchaser of the goods for value of Sale of Goods Act. Sorry, for the value under the Sale of Goods Act of 1930. Bona fide purchaser है, इसका मतलब the purchaser is not aware of defect in the title of the seller. That's why it is called as bona fide. There is no mala fide intention. The buyer is not hand in gloves with the seller, who himself is not having the better title to the goods. That is not the situation. The buyer is innocent. The buyer is completely unaware that the seller is not having better title. In that case, can the seller transfer better title to the buyer? So in this type of question, which is a 6-mark question, they have asked 6 different situations. So every situation is going to carry 1 mark. Don't write too lengthy answer. Write a small answer, proper answer. First part, mentioned under the Sale of Goods Act, the basic rule is no seller can transfer better title to the buyer than he himself has. That is, the seller can transfer only that title which he himself is having. If the title of the seller is defective, then by default the title of the buyer is going to be defective. However, This rule has got following exceptions. So this is the introductory para, and then you are going to write the 6 different situations. उसमें आता है तुम्हारा mercantile agent रहेगा, या फिर वो unpaid seller रहेगा, या फिर जिसने voidable contract में goods purchase करके रखा हुआ है और अभी तक voidable contract को cancel करने वाला option सामने वाले पार्टी ने exercise किया हुआ नहीं है. ऐसे जो अलग अलग situations है उसको सबको cover करने का है. The institute has given an answer here. You can check it, sale by mercantile agent. They have given even this particular part. He was in possession of the goods. Yeah. He was in possession of the goods or documents with the consent of the owner. Yes, that means the mercantile agent is having the goods which are not stolen from the owner. If the sale was made by him when acting in the ordinary course of business as a mercantile agent and the buyer has acted in good faith. That is anyway, the question itself is telling that buyer is acting in bona fide situation. So this is section number 27 to section number 29 or 30, okay, of the sale of goods act. So mercantile agent is considered on the sale by joint owners when the buyer is unaware that the person is not the whole and sole owner, but he is a joint owner, but buyer is unaware of the same and is buying in good faith. In that case, it is accepted. Then is sale by a person in possession of goods under the voidable contract. And then next one is sale by one who has already sold the goods, but he is still continuing to be in possession of the goods and document of title, etc. Next, sale by a buyer obtaining possession before the property in the goods has vested in him. So for example, seller return basis, here the exception is hire purchase. Under hire purchase agreement, you cannot sell unless until you have completed the last installment. And then effect of estoppel, when the owner is stopped by the conduct from denying the seller's authority to sell, then the transferee will get a good title against the true owner. But before the good title of the estoppel can be made, it may be shown that the true owner had actively suffered or held that other person in question as a true owner or as the person authorized to sell the goods. Many a times I have seen that students find this particular point to be difficult to write. Don't unnecessarily venture into it. Anyway, they have asked only any 6 points. Then next, sale by unpaid seller. This is already known to us. Section 54 may have a point here. And then sale under the provisions of other act. For example, there can be official receiver under the Companies Act, or there can be auction, etc. Then in that case, or sale of finder of the goods, that person who is entering into now automatically a quasi contract. He's a finder of the goods. He's trying to locate who is the real owner, but real owner is not available, and the goods are probably perishable goods. In that case, he sells the goods, keep the cash, and then whenever the original owner is available, he can give away the cash. That's what is considered. In such a case, the buyer of such goods which are sold by a finder of the goods, who himself is not the owner, still the buyer can become the owner of the same. And last part, sale by the pawning can convey a good title to the buyer. That is the pawn shop. That is considered here. So these are the points. Out of these 8 points which are given, you can write any 6 points, whatever you find convenient. Next one, ABC associates a partnership firm with A, B, and C as senior partners engaged in the business of curtain manufacturing and exporting to foreign countries. Okay. On 25th of August 2020, they inducted P, an expert in the field of curtain manufacturing, as their partner. Okay, they have taken some person as a new partner. On 10th of January 22, Mr. P was blamed. Okay, was blamed. बोला है. ED डाला हुआ है. ED मतलब it has already happened. He was not kept in dark. He was being blamed. He was being told that there is some problem with him for unauthorized activities and thus expelled from the partnership by the approval of all the remaining partners. Okay, approval of not majority but all the remaining partners. So 2 things have happened. Number 1, Mr. P, who is an incoming new partner, whom they only have admitted for he being an expert, he is now being told, he is now being blamed that you are doing unauthorized activities. So it's not the case that he's kept in dark. He's completely aware about the opinion of other partners about him. And what are they expecting? What are they telling him to do or not to do? And then all other partners have consented to remove this particular partner. Examine whether the action by the partner was justified or not. This is called as expulsion of a partner. Expulsion of partner can take place when certain things are properly communicated. Number 1, that the expelled partner is communicated or given a notice of the reasons of his expulsion. And then the expulsion is a decision taken by majority of the partners. In this case, it is taken by all the partners. So that means it is automatically majority of the partners. In this situation, the expulsion of the partner becomes valid, and therefore Mr. P can be considered to be validly expelled. He cannot claim that I'm still a partner. If they would not have blamed him, if they would have kept him in dark and directly would have gone for expulsion, then probably P could have claimed that the expulsion is unauthorized, because he was not given an opportunity to understand exactly why he's being expelled, and he was not given an opportunity to give his presentation for the same. Okay, but here both the conditions are properly fulfilled, And next point, what should have the factors to be kept in mind prior to expelling a partner from the firm by other partners according to the provisions of Indian Partnership Act? Number 1, it should be mentioned in the partnership deed. Number 2, proper communication is done to the partner. Number 3, the expelled partner is given an opportunity of being heard. And number 4, all other partners in majority have decided to go for expulsion. These are the conditions to be completed. So first question is 3 marks and second question is 3 marks you can consider for the purpose of this thing. Let us consider next question. Question number 5. Mr. Dheeraj was running a shop selling good quality washing machines. Mr. Vishal came to his shop and asked for a washing machine which is suitable for washing woolen clothes. Mr. Dheeraj showed him a particular machine which Mr. Vishal liked and paid for it. Okay, that means the goods are sold after sample or actual inspection. Okay, goods are as per description because उसने बोला उसको woolen clothes को ही wash करने के लिए चाहिए. Later on, when the machine was delivered at Mr. Vishal's house, it was found that it was wrong machine and also unfit for washing woolen clothes. He immediately informed Mr. Dheeraj about the delivery of the wrong machine. Mr. Dheeraj refused to exchange the same, saying that the contract was complete after the delivery of washing machine and payment of price. With reference to the provisions of Sale of Goods Act of 1930, discuss whether Mr. Dheeraj is right in refusing to exchange the washing machine. Now, Dheeraj is the buyer. He has gone to Mr. Vishal's shop and has gone for specifying exactly what is the purpose for which he is buying the washing machine. He has inspected the machine. He liked the machine. He paid for the same and thereafter he has received the same. And now he has found that the goods or the machine which is delivered to his house is not matching with the description which was explained by him in the shop and the machine which was inspected by him in the shop. That means here you can see that the goods are not as per sample. So this is sale by sample and description. You can say sample actually speaking, but yes, you can write it in the examination, sale by sample and description. In that case, the implied condition states that such sale or such goods should be matching with the sample, matching with the description. If they are not matching, in that case, it's an implied warrant. Sorry, it's an implied condition. Since it's an implied condition, that means the contract can be rescinded, or he can demand the money back, or he can specify that I want a replacement of machine. So these are the options which are available to Mr. Dheeraj. I'm repeating again, this is the question of sale by sample or sale by description. This is covered by implied condition. Conditions are different and warranties are different. In case of breach of condition, the contract can be cancelled. In case of breach of warranty, contract cannot be cancelled. So here you can see that since it's a implied condition which is broken, Mr. Dheeraj has got every right to specify that I want to cancel the contract, give me my money back, or I want to cancel the contract. I want to continue with the contract, but give me replacement of the goods. Okay, so these are the things which can be covered. Next, Mr. Rajiv, an assessee, was a wealthy man earning huge income by way of dividend and interest. He formed 3 private companies and agreed with each to hold a block of investment as an agent for them. The dividend and interest income received by the companies was handed back to Mr. Rajiv as pretended loan. This way, Mr. Rajiv divided his income in 3 parts in a bid to reduce his tax liability. Okay, decide for what purpose the 3 companies were established and whether the legal personality of all the 3 companies may be disregarded. So these are 2 different cases. I think one was the Solomon versus Solomon and Company, lifting of corporate veil, and there is one case I am not quickly recollecting the entire name. Some Mr. Pvt and Jaganlal or something like that. Let us check whether the institute has given those names here. Yes, Solomon versus Solomon, lifting of corporate veil is by default applicable here. Yes, Solomon versus Solomon is there. Very good. And the second case which I want, yes, this is Sir Dinshaw, Manekji, Petit. Yeah, this is Petit and Jugilal versus Commissioner of Income Tax. These are the 2 different cases which you are supposed to cite. If you can write both the cases, great. If you cannot write both the cases, at least write Solomon and Solomon versus Solomon and Company, which is a very famous case anyway, is easy to remember. So in this case, it is mentioned that generally the company is different and the owners are different, and the justice or the judge or the court does not have a right to lift the corporate veil. They'll have to keep the identity of the company and the shareholders to be separate. However, in certain cases where it can be seen that the intention of creation of company is basically for the purpose of tax evasion, in that case the corporate veil can be lifted and the company's separate existence can be denied. Here you are to mention that based on the facts of this case, it can be seen that Rajiv has not started the company for the purpose of doing any business. It is basically for the purpose of separating dividend income which he was getting under his own name, thereby reducing the tax liability. So the purpose of formation of the company is purely to save the tax or purely to evade the tax. That is the purpose. And then Mention about Salman and Salman versus Salman and Company. Mention about Sir Dinshaw Manekji Petit and Jugilal versus Commissioner of Income Tax, and specify that in these two cases it is mentioned that although corporate veil cannot be lifted every now and then, however, when the intention is to evade the tax, then the court has the authority to lift the corporate veil, which was done in the case of Sir Dinshaw Manekji Petit, Jugilal and versus Commissioner of Income Tax. So that's what you are going to write. Question number 6. Now let us consider question 6. Define consideration. State the characteristics of valid consideration under the Indian Contract Act of 1872. I'm very sure that many of you are going to write this question. It's a relatively easy question because consideration is something which we like. Section 2, subsection D, what does it specify? That consideration, when at the desire of the promisor or any other party has done or abstained from doing something, does or abstains from doing something or promises to do or abstain from doing something, then such an act, abstinence or promise is treated as consideration for the contract. Then mention all the different features. It can be past, present, future. It is to be moved at the desire of the promisor. It can be given by promisee or something like that. So all these features are very easy. I don't think I need to explain this question. It is quite easy to understand. Next, what does dissolution of partnership firm takes place under the provisions of Indian Partnership Act? When does dissolution of partnership firm takes place? Okay, dissolution of partnership firm. 4 marks they have told. Very good. Yeah. Dissolution of partnership firm, you can specify upon completion of the contract, upon completion of the agreement, if the partnership is for a specific time period or specific purpose. In that case, upon completion of purpose, completion of time period, the partnership can be dissolved. If the partnership is at will, in that case, it can be dissolved by giving by a notice by any single partner to all other partners about his intention to dissolve the partnership firm. Before writing these points, don't forget to write the point of dissolution of partnership is different from dissolution of firm. Upon admission, retirement or death or insolvency of any partner, that partner is getting out of the partnership relationship is coming into an end, but other partners may decide, if authorized by the partnership deed, to continue with the partnership firm despite of the fact of death or retirement of any other existing partner. Then write down the points about partnership at will, partnership for a specific purpose, partnership for a specific period, and then you can also specify that partnership can be dissolved under the order of court when the partnership business has become illegal, or when all but one partner has become insolvent, or when partners have become unsound mind, or the partnership business is dangerous for the society. In that case, the courts can again dictate the partnership firm to be dissolved. These are the points to be considered. Next one, Aqua Limited was registered as a public company. Okay, registered as a public company, already public hai. There are 230 members. Private limited के लिए 200 member बोलते हैं हम लोग. Okay, there are 230 members in a company as noted below. Directors and their relatives 190. ये तो चलेगा, इसका कुछ problem नहीं है अपने को. They can be counted as members. Okay. Next, employees 15. Now I hope you remember that the definition of number of members or definition of members for the purpose of private limited company excludes the ex-employee and present employee members. So these 15 members are members, but for the purpose of counting the number of 200, they are not to be included because they are the employee members. Next, ex-employee members, shares were allotted when they were employees. So these are not the people who have become shareholders after retirement. When they were employees, at that time itself, the shares were allotted to them. So they are also required to be ignored or removed while calculating the limit of 200 members. Next, 5 couples holding shares jointly in the name of husband and wife. So 5 into 2 is equal to 10. However, when the shares are held jointly, I hope you remember this point. When the shares are held jointly, in that case, all the different people who are jointly holding the shares are counted as one member. So here it is not 5 into 2. It should be considered as 5 into 1. That means it becomes 5. So this 10 is to be considered as 0. This 15 is to be considered as 0. This 190 is to be considered as 190. No problem. And others are 5. So the number of members which the company is having are already 200. In reality, one can argue that nahi sir, और 15 भी है और 25 10 भी है, मतलब और 25 members है. मतलब the company can say that sir हमारे total 225 members है, तो हम लोग public limited company है अभी भी. लेकिन याद रखना ये जो 15 और 10 members है, 15 and 10 members, 25 members, they are to be ignored. And ये जो 10 को तो पास consider करके हो ही गया है. So actual number of members at present company is having is only 200, not 225, not 230. The board of directors of the company proposes to convert the lab into a private limited company. Great. So उनको already 200 numbers ही है. Also advise whether the reduction in the number of members is necessary. Reduction is not necessary Because for private limited company, maximum number of members can be 200 and they are already 200. So they need not reduce it again. If it would have been 225, we would have said, okay, 25 ko kam kar do. But 225 is not applicable. Why? Because ex-employee and present employee members are not counted for calculating the limit of 200. Similarly, joint members are counted as one member for the purpose of counting the number of members. Accordingly, the company's number of members, although appear to be 230, they are only 200. Since they are only 200, the company is already well within the limit of private limited companies number of members. That means no more members are required to be removed or reduced, etc. So this is the point to be considered. This is how the question is to be solved. The remaining questions are of BCR. So मैं उसके बारे में बात नहीं करता हूँ. I am very sure that you must have found this discussion to be useful. I'm going to discuss one more paper and then I'll go for the past examination papers also. So stay tuned. I'll be uploading the lectures very soon. Thank you very much.